Hello, Kelly Blatnik with Blatnik Law here to discuss alimony in the state of Nevada. Now this is based upon 2020 current statutes. Those statutes can change. One of the largest changes that occurred was not in the state of Nevada, but when the tax system was overhauled. Prior to the tax system overhaul, alimony was taxable to the receiving spouse and not to the paying spouse. And what that did would lower the tax rate of the money that was paid in alimony, because typically the receiving spouse has less income than the paying spouse, and as taxes or income taxes are on a graduated scale, the less money you make, the smaller percentage of taxes you pay. Now, when alimony is paid, that money is paid with post-tax dollars from the payor, meaning the person paying the taxes now has to paying the alimony now has to pay taxes on that alimony. The factors that the courts in Nevada look at are multifaceted, and this is from Nevada Revised Statute, Chapter 125, Section 150, subsection 9. Each spouse's financial condition, the nature and value of each spouse's property, each spouse's contribution to the marital property, the length of marriage, both spouses' income, earning capacity, age, and health, the marital standard of living, the recipient spouse's career prior to marriage, whether either spouse obtained specialized education, training, or marketable skills during the marriage, either spouse's contribution as a homemaker, the property a judge awards the supported spouse in the divorce, meaning if there's some disparate award of property, and each spouse's physical and mental condition as it relates to the financial condition, health, and ability to work. What does that mean? What that means is that there is broad discretion among the judiciary to determine who pays alimony and how much. Generally speaking, the longer the marriage and the greater the disparity in income between the spouses, the greater the probability that alimony will be awarded. Alimony can be lump sum, rehabilitative, permanent, periodic, which is usually the worst that when people hear of alimony. Oh no, permanent periodic is the longest in duration, and it really is at the discretion of the judge. So a lot of couples will like to come to an agreement as to alimony. Unlike child support, where there are formulas that you can plug in, there are so many factors for alimony that there aren't any really hard set fast calculations, which personally I prefer to be able to have a calculator to plug things in. The two types of calculations that some of the case law shows is half the length of marriage for 1/3 the disparity in the income, or 1/3 the length of the marriage for half the disparity in income. Once again, not all judges follow that. It's a guideline that some cases have found, but by and large, when you're looking at alimony awards, the longer the marriage, the greater the disparity in income, the more likelihood that one spouse will be paying the other alimony. And the nature and type of that alimony will be directly related to all those factors that were discussed above, which means that it's really a good idea to discuss with your attorney the entirety of the marital estate and the ability of each spouse to work after the marriage is dissolved in trying to determine what type of alimony you should or should not be offering to the other spouse.